Johnny, do you want to Counselor Kidwell?
Yeah, let's get real formal.
Let's be
so much
formal.
easier. No, I appreciate you letting me kind of kick us off here a little bit, and obviously, Dr. Coach, thank you for really setting this up and getting it all going. I think this is a great topic, and it's one that many people are interested in, and I'm sure that even after we record this and put it out for everybody to see, it'll get more views than we could imagine. And obviously, I'd like to welcome our Attorney General Sara Hill. Ma'am, thank you for being here today and talking to us all about these important topics and answering a few questions that Cherokee citizens really want to know about and understand and get a better grip on. We truly appreciate you taking time out of your busy day to be with us and talk to us a little bit about these legal issues impacting the Cherokee Nation. So with that, ma'am, I'll just kind of hand it to you and let you introduce yourself, obviously, and maybe even talk about a few things right off the bat that you feel are important. And then once you get a few of those things off your chest, so as to speak, I've got a few questions here that I'll ask and that you can speak to, and then Dr. Coates, she's monitoring the chat area there, and she'll be fielding some of the questions that pop up there. So, with those housekeeping items out of the way, ma'am, I'll toss it off to you.
I very much appreciate the opportunity to be here. It's a great honor to talk to especially the at-large community. In a community meeting like this, I've been to various meetings before out to California. I enjoy the weather when I go visit the Southern California groups, and I look forward to being out there again sometime in the future. But I appreciate all of you taking time out of your days to talk about some of these issues that I have to live with them every day. And it's always nice to get that off my chest with my fellow Cherokees and talk through some of the frustrations that we have sometimes and some of the great challenges and great opportunities that I think we have. I've been the Attorney General now. I became Attorney General in 2019, I think. And when I became the Attorney General, it was the job of the Attorney General looked a lot different than it looks today. So I thought that one way to start would be to maybe sort of walk you all through the last couple of years of my life, the short version of how Cherokee Nation's changed, how the job of the Attorney General has changed. And I've got some slides. I'm going to attempt to share my screen. We'll see if that is something that I can do. Can you guys see my screen?
Sure do.
Awesome. So I've given this presentation a few times. Typically, I'm talking to other community groups, maybe not Cherokee community groups, maybe just community groups on the reservation, talking to them a little bit about public safety. But I think this might be a pretty good place to start. You can see it's an older slideshow, but it covers a lot of the ground that I think that people, especially if you're not someone who lives in Oklahoma and has to deal with these issues on a daily basis, it might be good to have a little bit of overview of it, I think. And of course, one of the things that I think it's important to sort of see the map, especially if you're not an Oklahoman, is, you hear a lot of people talk about McGirt, and that's, of course, what I'm going to mostly be talking about today. I'll also talk about Brackeen a little bit, but really talking about McGirt and what it means for the Cherokee Nation and for the other 5 tribes and what it means for Oklahoma as a result of that decision, because it has been a decision that's kind of shaken a lot of people's long-held beliefs. Of course, lawyers for the 5 tribes had never been under any impression. We had always believed that the reservations of the tribes had never been disestablished. Lawyers in Indian country, smarter, more experienced lawyers than me, had for years been talking about the reservations of the 5 tribes and thinking about these issues deeply. How do we get these issues in front of the court? And actually, the case came about not because of anything the tribes did, but because of the argument of a criminal defendant. And we'll get to that in a little bit. But this is the part of Oklahoma that is affected the most. Now, Quapaw is not on here, but there's also the Quapaw Reservation has also been recognized by the courts since the decision in McGirt. And it's probably roughly half of the land mass of the state has been affected in its jurisdiction by the decision in McGirt. A lot of people, there's talking to lawyers about McGirt is a different experience than talking to people who live in the community and Cherokees who are impacted by it. And I tend to talk about it much more in the practical terms, because it's the practical day-to-day things in the Cherokee Nation that are the issues that I have to deal with every day, and the issues that your counselors have to deal with every day, and the chief. Really, I think, part of understanding McGirt means understanding this sort of cycle of erasure of tribes that have been going on for a long time in Oklahoma. Even going back into the 1930s, after statehood, there was sort of this sense, I think, from a lot of Oklahoma lawyers, Oklahoma government officials, that the tribes were just gone, that at statehood, somehow the tribes had just disappeared, their land disappeared into the state, and they were simply gone. And when there were a lot of different laws that made it clear that hadn't happened, that wasn't what the law required. The tribes hadn't gone anywhere. They weren't terminated. That was clear. But you can get to the point, I think, where if you're told something long enough and you're told it with enough vigor, that people began to believe it is the truth. And I think that was an issue that a lot of the tribes were dealing with into the 1970s. Not just the suppression of the tribal boundaries, but suppression of the tribal governments themselves by the United States and by state actors as well. I understand that there's a new movie coming out with Martin Scorsese at the helm, talking a little bit about what life was like for tribal members who possessed land and valuable property. It was a difficult time for all of the tribes from statehood until the 1970s. In the 1970s, we began to see a change. That tribal erasure began to kind of fall apart in the face of the truth. There were lawyers who were coming back before the Oklahoma courts and arguing, sometimes tribal lawyers, people who are, in many cases, who walked into practicing law in the 1970s, people I can still talk to, who are still tribal advocates, began to bring these cases in front of the court saying, well, this is tribal trust land. If it's tribal trust land, there's no way that Oklahoma has jurisdiction over this. And they would bring these cases to the courts, and they began to win. And they began to win in the state courts and the federal courts. And so you began to see a very grudging, sometimes sort of hysterical response from Oklahoma as these battles were being won. I have a great clipping that I got from Susan Work. She's a wonderful Choctaw lawyer, one of the smartest people that I know. And she has a clipping from the 1980s, early 1980s, after the tribes had won. And it was a criminal defendant, again, who won a case at the Chilocco Indian School. It was on tribal trust land, or it was a dependent Indian community. And the state had no jurisdiction over it. And that's what the court held. They didn't have jurisdiction over this. And there's a great clipping of that article where the local sheriff is saying, how can this be possible? Oklahoma's coming apart at the seams. How can the state survive if it does not have sovereignty over these crimes? Exactly the same rhetoric that we see today from many of our state officials. So this reaction and overreaction by the state officials at the time began back in the 1970s and 80s. And basically every time the tribe has won a court case, be it the tax cases from the 1990s, where the Oklahoma Tax Commission went to the Supreme Court multiple times and lost multiple times on issues where they tried to tax the tribes. There was a particular case where a local sheriff tried to put a tax lien on Governor Anatubby's house. I mean, it has been tumultuous throughout Oklahoma when tribes have won these cases. And so knowing that history of tribal erasure, and then thinking about sort of the overreaction that Oklahoma has had anytime the tribes have successfully exerted their influence or their jurisdiction or their exemption from state regulation, you have seen this sort of overreaction. And so I think all of you can probably see where this is going, right? You can see the prelude here. Maybe there shouldn't have been so much surprise when, after the decision in McGirt, we began to see this reaction and overreaction by the state, these claims that Oklahoma is falling apart at the seams, all of this fear about what tribal governments mean and what they can do. So I want to take you to a little snapshot of the 2019 Cherokee Nation. So this would have been roughly about the time I came into office. McGirt was pending, but not yet decided, or the issues in McGirt were pending, but not yet decided. And in 2019, the Attorney General's office filed 62 criminal cases for the year. It was kind of a slow year, but not exceptionally slow. I mean, it would have been unusual for the Cherokee Nation AG's office to file 100 criminal cases in a year. Almost all of those cases came from from the tribal casinos, or they came from restricted land. It's just pretty unusual for us to have a lot of criminal cases. There were roughly 30 Cherokee Nation marshals employed. You can see one of them there at the Remember the Removal Bike Ride, doing, most of what they've always done, which is, work tribal cases up, working closely with the federal government, the U.S. Attorney's offices, as well as the AG's office. We had one full-time district judge and one part-time district judge. Those were the resources that we had on hand in 2019, which is not to say that we didn't know that this was coming, or that it was possible that the McGirt decision would come, because by that point, the Murphy case had already been up to the 10th Circuit. The Murphy case was the case we all thought would be the reservation case. The Supreme Court heard the case, heard oral argument on it, and then just didn't decide the case, just let the term go without making a decision. So it rolled over into the next term. And it was in the second term that the McGirt case came up, and the court, of course, accepted cert in McGirt, ultimately deciding that case and then also deciding Murphy at the same time. There are, just to sort of describe the Cherokee Nation Reservation, I think most of you are probably pretty familiar with this, but I still think it's interesting to look at the statistics. I like to look at numbers. I think they're informative, they're helpful. And the Cherokee Nation Reservation is roughly 7,000 square miles, which is about 10% of the total land base. There are about 500,000 people living inside. It's not exactly the same. The Cherokee Nation tribal statistical area, that's kind of the census area, but it's roughly the size and shape of the reservation. And so there's roughly, 500,000 people living in there. And about 143,000 of the people living within those boundaries, which is about 28% of the total population, was Cherokee, our Cherokee citizens. And so that just gave us, we were looking at trying to predict what sort of numbers we would have. Of course, I don't know how many Muskogee citizens are living in the Cherokee Nation. I don't know how many other tribal citizens were living in the nation, but I assume that the Cherokee Nation would mostly have, its tribal citizens would mostly be Cherokee. So it gave us a little bit of a clue of what our possible, base would look like in terms of criminal jurisdiction. And then, of course, the nation can charge in the reservation. The tribe has jurisdiction over non-Indians, over Indians who commit crimes against other Indians or non-Indians. And the tribe also has jurisdiction over a certain class of non-Indians, and that is non-Indians who commit domestic violence crimes on the reservation. And if they fit into the rules that VAWA provides, then under some circumstances, the Cherokee Nation can also exert jurisdiction over non-Indians. So the Supreme Court's decision came down in July of 2020. And, the McGirt decision is not particularly revolutionary by its own terms. I mean, what the court did was follow its Supreme Court, what they call stare decisis. It followed its previous decisions. There were already rules about how to determine if a reservation should be or has been disestablished by Congress. And all the court really did was take those rules that had used many times before and apply them to the facts in Oklahoma in a very methodical way, in a way that had a lot of intellectual credibility. And I think that was the thing that was the most surprising about it, because, tribes don't often fare super well at the Supreme Court. And there are lots of times where we have seen the court faced with making a decision that might, be problematic for a state, find ways to make different decisions. That wasn't the case in McGirt. Justice Gorsuch was very disciplined about how he applied the facts to the law. And really, the Supreme Court's holding was relatively simple. It said that reservations are created by treaties, and each treaty must be considered by its own terms. And that once a reservation is created, it cannot be disestablished except by explicit action of Congress. So if a reservation exists, it doesn't just fade away because people get tired of it being there. It doesn't go away because people in Oklahoma, governments in Oklahoma, decide that it's inconvenient for the reservations to still be there. Instead, they said, we're going to follow the rules. Unless Congress has explicitly said we are disestablishing this reservation, it continues to exist. And applying that law to the facts of the Muskogee Nation, it's clear that Congress had never taken any such action, and that the reservations therefore were affirmed. Of course, this case really specifically dealt with the Muskogee Nation. It didn't deal with the other 5 tribes. But the 5 tribes have been hanging around together for a really long time. They have very similar legal histories. We came from the same region of the United States. were settled in the same area. Our treaties were negotiated at the same times, often, or around the same times, with many of the same forces in play. The 5 tribes, I think, have always communicated with one another about what was going on in those reservations. So there are differences between the treaties, but they're very similar in a lot of ways, in all of the important ways. So when that happened, when McGirt was decided, and I was the Attorney General by then, it was, I knew immediately there is no way that this goes any other. I could not see any other outcome, but that the reservations of the 5 tribes, all of them, had been established and had never been disestablished. There just wasn't enough difference in how the federal laws had affected the tribes for that to be the case. So I knew that day, I didn't know exactly when we would have a decision about it, but I knew that a decision was coming and that would be the result. And it was. The Oklahoma Court of Criminal Appeals, I drove all over the 14 in these different cases, because the issue would come up in these criminal cases. Individual defendants had filed motions saying, I'm an Indian, this crime occurred in the Cherokee Reservation, you don't have jurisdiction over me, county court. And the district court was being told by the Oklahoma Court of Criminal Appeals, and that's the highest court in Oklahoma for criminal matters. They were being told, well, go back and look at these issues and see if you can determine whether or not follow the rules of McGirt and report back. And so there were different cases like Hogner all over the counties in the 14. And so I would drive there and we would file briefs and make the arguments in those cases. And then here's just a little quote from Hogner. We also find the district court appropriately applied McGirt to determine that Congress did establish a Cherokee reservation and that no evidence was presented showing that Congress explicitly erased or disestablished the boundaries of the Cherokee Nation or that the state of Oklahoma had jurisdiction in this matter. And they dismissed Mr. Hogner's case. And so that was, when that happened, then it was just like a waterfall. Then all of the other cases began tumbling along at the same time, which meant that my office now had a lot of questions that we had to answer. What happens to the cases of people who have been illegally prosecuted by Oklahoma? What if you have someone who's been in jail for 20 years for a murder conviction, but they're an Indian and they were prosecuted for a murder on a reservation? How would we even identify those cases? How many new criminal cases are we going to have now that McGirt is in effect? We don't know. We have some ideas. We can do the math, but we're not sure how many new cases we're going to have, how many of those people will need to be incarcerated, and for how long. What about juvenile crime? Is juvenile crime going to be treated by the courts the same way as adult crime? Are those cases going to be dismissed? And how do we coordinate information across dozens of law enforcement agencies? Because the Cherokee Nation Marshal Service is not present in every county. They have a presence. They may have an officer that's available there, but they are not there every day in the counties and in the city. So we have to take these cases directly from local law enforcement. And all of those questions are part of what I thought the bigger and more important question was, which is how do we build and maintain community trust in tribal justice systems? There are people who I think hear tribal court and they think about something very exotic, right? They think, oh, it's going to be something really amazing or something it's really strange, and they don't understand them because they've never been in a tribal court and they don't know how to conceive of it. So we have this sort of really big hill to climb answering some of these questions. These were the things that were going through my mind and had been going through my mind for some time when McGirt was decided, and then again when Hogner was decided. So there's some of these things that we were able to solve. It took time to solve them, but we solved all of those issues in different ways. One of the things that we were almost immediately faced with was what to do with the municipalities. So we have the counties, and in Oklahoma, most people, tend to live in cities just like everywhere else. You have the counties and you also have cities. Municipalities typically have misdemeanor jurisdiction. So it's things like parking tickets, speeding tickets, maybe, in public intox tickets. Those things are pretty common. And so one of the things that we were concerned about, or that was expressed to us from the cities was, hey, we don't necessarily have a problem with this decision in McGirt, but we're concerned about our local law enforcement. If the tribe is getting all of these tickets now and all of the fines that go along with those tickets, especially if you have a community that's rural or a community that has a particularly high population of Indians, it could really impact their bottom line. They were concerned because that ticket writing often supports those local police. And so that was one of the concerns that was raised to us. How are we going to deal with this issue of municipalities? What if we take all of this ticket money out of the communities, what's that going to mean? And there are big municipalities in Cherokee Nation, like Owasso, which has probably, I'm sure it's got more than 40,000 people today. And then tiny municipalities like, okay, with its 600 people. What about detention costs and logistics? The Cherokee Nation has a historic jail museum that you can visit, but we do not have our own jail or any kind of detention facility of our own. We have always contracted with the local counties for that. That contract is pretty important to the counties, just like it's pretty important to the tribes. We need detention space. And these jails were built for the most part with public money. Your local jail is built by a bond issue, taxes of the local community. If they have a big jail and now they no longer have inmates in there, what happens to that jail? You begin to have lots of issues with upkeep and maintenance. So that can be a burden on a community. So one of the easy solutions there was, well, we'll just continue to contract with the state. So that was one thing that we had. But on the other hand, we're not getting that at cost. We're having to pay the county for the benefit of that, having that detention space. And then there's the logistics of how we get medical care, all these other issues that were involved in that. We had to think about our criminal code. Our criminal code had not been really updated in a really comprehensive way in a long time. And because if you have 60 criminal cases a year, it just was never a particularly high priority. It was a real high priority now. If something is a crime in Oklahoma, but it's not a crime in the Cherokee Nation, it's going to lead to a lot of issues. And the reverse is true. Local law enforcement, if you are let's say you're a police officer in Owasso, or a county officer in Rogers County, Oklahoma law, and that if you're taking someone to jail, what the elements of the crime are. If it's totally different in the Cherokee Nation, you really don't have the tools then to write that. All of that job becomes much more complicated. So that was something we knew we would need to do, is update that code. And then we also needed massive technology upgrades. My office, which had filed 60 criminal cases a year, we really just didn't have the technology to deal with the influx of cases that we were sure was coming. But we were able to solve a lot of those problems in different ways. Here is the MOU, which was sort of solved our municipal issue. We worked with the local cities. We talked to them a lot about what their concerns were, what their goals were. And really for most of them, it came down to, we want stability. We want to know what's going to happen with these tickets. We were able to communicate that to our citizens so they know what to do if they get a ticket. And so we sat down and worked a lot of those issues out. That also helped with our other issue of building public trust in tribal justice systems, because people in local municipalities, if they got a ticket in Owasso, they could go to the local court there, they could pay the ticket, and that $30, the tribal council allows the city to keep the fine in Owasso. So Owasso gets to keep the fine money, and only $30 of that ticket is remitted back to the nation. So it's kept as a donation to the local law enforcement. That $30 fee that they remit is the $30 fee they would have had to remit to Oklahoma if it had been an Oklahoma ticket. So it's literally it's a wash from a financial standpoint for the local communities who sign on. And so that's something that, that I couldn't have done that via an MOU but the tribal council could agree to let them maintain those costs as a donation to the municipality. And today we have 18 different municipalities that have signed on to the MOU, and those are working extremely well. If there is, as sure all of you are aware, most people who get a ticket in a city, they just want to pay it. And that's what happens to most of them. But the nation still has jurisdiction in these municipalities. And if someone wants a trial, then that case is tried in the Cherokee Nation district courts. So the courts are still overseeing all of that. And the justice system of the nation is still ultimately who is at the bottom of this system. But the payment of the money in this way helped keep local police in the communities, which is pretty important. So we went from 60 cases to, in the first year post-Hogner, we filed 3,700 criminal cases, exclusive of traffic citations, of which there were another probably 2,500 of those. Detention costs are running into the millions of dollars for adult and juvenile detention. We also have 13 jail agreements now, or agreements in 13 counties. And we also have multiple municipal jail agreements. The only county that's sort of been the holdout has been the city of Tulsa, but we do have a transportation agreement with them. And we can reimburse the city of Tulsa for the cost of transportation, medical expenses that are associated with an arrest of a tribal citizen. So we had fortunately had an opportunity to really prepare for that. I prepared for that by hiring 8 new full-time prosecutors. I only had 1 full-time prosecutor when we started, and today we have 8. And I still need a few more, honestly. My folks are still running at such high capacity that I am concerned over the long term that they will begin to have burnout issues if I don't get them some more help. They really are an extraordinary group of people. One of them is a former state court judge. She spent almost 25 years on the bench in Cherokee County and had just left right before McGirt came down. And she's a Cherokee citizen, and she came over to help. Multiple other of our full-time prosecutors came from the state courts. When they saw that McGirt was coming, they were tribal citizens and they were ready to come to Cherokee Nation and pitch in. So we were able to get experienced prosecutors from Tulsa County, from Cherokee County, from Delaware County, and bring them over to the Cherokee Nation. And it's been, it's not been easy for them. Nothing about this has been easy, but we have been really dedicated to getting it right, and not just getting it right, but getting it done in a way that really builds that trust in tribal justice, which has meant having long meetings with local law enforcement so that they understand, what we're doing. We provide a law enforcement protocol to all the different municipalities and counties that do law enforcement in Oklahoma. And that just basically explains, here's the number that you can call if you need a prosecutor in the middle of the night because you have some question. Here's where you can call if you want to check and see what the status of a case is. It means us being able to provide to local law enforcement. If they bring us a case, they want to know what happened to that case. So we've committed to do that. We talk to them and make sure that they understand if we decline a case, which we sometimes do, which all prosecutors' offices do, that we communicate that to them. Not only that we declined it, but why, so that they aren't left thinking, the tribe doesn't care what happens to these cases. No, we care a lot. And we want them to know if the investigation was such that we did not feel like we could move forward with the case, we want them to know what we felt the failures were in that investigation so we can get it right the next time. So that sort of back and forth, having those doors open so that they can come to us with their complaints and we can come to them when we have issues too. That was part of this logistical process, which took, we've had a year now to work it out. I have to say, I am frequently surprised by how well it does work. We really have gotten very used to each other. Now, most of the cases we get directly from the counties because everyone understands the rules, which is not to say that it's been cheap. Of course, the detention bills that the nation has are running into the millions of dollars easily for all of the different detention that we have to pay for today. I hope I'm not boring all of you. I know this is kind of a lot. The nation also has multiple agreements for juvenile detention. This was something the nation didn't really have much of a juvenile detention program at all when McGirt was decided. So this was something we sort of had to build from the ground up. Today, juvenile detention has 8 full-time employees. They work very closely with OJA and the other local law enforcement. It says we filed over 40 delinquency petitions. That was back in October. Today, we've filed hundreds of delinquency petitions and taken hundreds and hundreds of referrals. So that's part of it. We have a judge who hears all of the juvenile cases. And we have multiple contracts with juvenile facilities. Juveniles cannot be held with adults. They have to be held in special facilities under special rules. So we have contracts with one of them with a tribe, the Sac and Fox, maintain a juvenile facility that they oversee. And we have several beds that we have available for detention from them. And then we also, of course, did all of this code work, as I explained, just to make it more consistent between the sovereigns, to make sure that any of our aging sections were more comprehensive and more modern, because the criminal law changes just like everything else changes. We also wanted to make it easier for public defenders to productively engage with tribal justice. If we had a totally different system that was difficult to engage with, public defenders would not want to come into our courts and take these cases. So we wanted to work hard to be sure that we had a system that people could engage with and would understand. And a lot of this information, if you're interested, you want to see what are these MOUs, or if you want to learn more about it, our website is pretty good. We keep it updated with legal information. And if you have suggestions for other things you might want to see on there, you can always shoot us an email and let us know. On the technology update, we were able to adopt Prosecutor by Carpel, which is a paperless system. Tulsa and Oklahoma City have used it for some time. We use it. We have a paperless office. So if my prosecutors go to court, they can take an iPad or a laptop, and all of the police reports, all of the discovery, all of that information is stored on our internal system, just to help the system move along a little bit quicker. It has lots of different abilities, and it's made it possible for my 8 full-time prosecutors to carry the kind of caseloads that they've been carrying. That technology has been important. And, I hired 8 full-time prosecutors, and I hired probably another 15 or 20 support staff, paralegals, investigators. It really does take a big team of people to prosecute crime. So then I'll just speak a little bit longer about some of the challenges that we're facing now. One of them is Castro Huerta. This, as you probably have seen, if you've watched Oklahoma, at all, you've seen that it's kind of been, the governor has had a difficult time accepting the reality of McGirt. And that has been, and the way we know that is that his Attorney General has filed something like 40 petitions for cert asking the court to overturn the case that they just decided last term. In every single case that came up, in every single reservation, they filed multiple requests asking the court to just go in and undo what they just did, which would really sort of violate that stare decisis we talked about, the court following its own precedent. And so we thought that it was, unlikely that the court would be willing to overturn something it had just decided. But Governor Stitt felt differently. He felt like with Justice Ginsburg having passed and Amy Coney Barrett becoming the new justice, that maybe that would be enough for him the court would just decide to accept cert and then just turn the whole thing over. That was his hope anyway. The court didn't do that. The court decided it would not rehear the issue of McGirt. It wouldn't accept cert on it, but it did accept cert on a slightly different question that the state was also interested in. And that question is whether the state has authority to prosecute non-Indians who commit crimes against Indians in Indian country. So they ignored question 2 there, but they granted cert on question 1. It would be too long for me to go into the reasons why. I think that that's a terrible argument. Our amicus brief on that, the 5 tribes together filed an amicus brief in this case, explaining to the court why we think the state has got it wrong and why the court should not, why the state does not have authority to prosecute non-Indians. The United States jumped into the case and filed an amicus brief as well in favor of our position. So we've got the United States and the 5 tribes, the Navajo Nation, lots of different folks have sort of jumped in. You can see the group here on the pro-state side. You've got the Environmental Federation, the Oklahoma District Attorneys Association, Texas, the Oklahoma Association of Chiefs of Police, and the city of Tulsa jumped in favor of the state. And then you see the pro-tribal amicus. We've got a really good and interesting group of folks that I think really did a good job on the briefing. So that case will actually be heard next week in front of the Supreme Court. It will have oral argument on the 27th. And then hopefully we'll have a decision by the court. It could be as early as June. So, I think one of the questions now that we are beginning to sort of work through the problems, I think you can see we've worked through a lot of them. We still have challenges, as you can see from Castro Huerta, and you can see, from the governor's office, his continued problem with it. The question I think that we're moving to is, Cherokee Nation is committed to improving law enforcement, but how can we use our strengths? How can we find a way to move away from this us versus them rhetoric, which has really gripped this issue in Oklahoma, and toward cooperation? Cooperation. I know Chief Hoskin would like to cooperate. I would like to cooperate with the state better. I would like to have productive discussions with the state because, we'll always be together. The tribes aren't going anywhere. Oklahoma's not going anywhere. We really have no choice but to find a way to work together cooperatively in favor and in support of public safety. And I think that that's some of the challenges that we face now, just looking into the future. So I have probably talked too long about all of this. And I haven't even talked about Brackeen yet, which I can do in a minute, but I wanted to take a break and give an opportunity for questions if there were any questions as a result of all of that, or whatever else, counselors would like me to.
Well, yeah, I think I really appreciate that that in-depth, broad look at everything that's going on and how so many things have been impacted, as you try to move forward. It seems, in preparing for tonight's discussion, there were really two things that people really wanted to hear about. And you just mentioned the second one was the Burkine, versus Holland and Indian Child Welfare Act. And I'll allow you to speak to that here in just a minute. But let me wrap up one last little bit. You talked about, you talked about the things, expenditures and things that we're going to have to do and buy and hire and get so many things going to be able to meet the requirements that really that stem from McGirt. One thing a question that we had received that I didn't hear you touch on much was about rehabilitation programs for the convicted. Now we talk about whether or not we're going to have to build a detention facility or a prison or however that might be, or rent more space and borrow more space. But a couple of the questions that I'd received focused directly on rehabilitation of the convicted. Are there plans moving forward for anything like that?
Yeah, I mean, we have the benefit, fortunately, of having some of that already. So even prior to McGirt, we'd had, I think it's in Diane Kelly's shop. She's the career services folks. They've had a lot of outreach to people who are coming out of prison and having to deal with the fact that if you're a convicted felon, it's really difficult to get a job. What are the pathways? It can be difficult to get a place to live if you don't have a job and there are all these different challenges that are faced by people that are coming out of detention. Cherokees don't see other Cherokees as throwaway people. These are all people that have a place in our communities, and we need them to take those places. They're fathers and sons and mothers and daughters, and finding a way to rehabilitate those folks and get them back into the communities that they belong in is incredibly important. That is not, my job typically is on the getting people into jail bit. It's not a job it's not something I like having to do, but that's the job of the AG's office, is to prosecute crime and to see that justice is done. I do think I know there's already a lot of time and energy put into rehabilitation because I see it coming out of career services, but that's probably something that they would know more about than I would.
Yeah, and I can say just from sitting, from my time, my short time here on council, we see a lot of things that come through that speak directly to that, and I applaud their efforts in trying to be more broad and more inclusive and kind of be more prepared for those things that are coming. If you don't mind, I would go ahead and let you speak to a little bit on the Burkine case and the Indian child welfare. That seems to be a hot topic now. For those that are watching, please don't think that we're finished with McGirt. I mean, we'll be able to ask a few more questions here toward the end. But while we have the Attorney General on the line, let's talk. I know that the Supreme Court said that they're going to hear, some arguments on the constitutionality of the Indian Child Welfare Act. I think that was in February that they had spoke about that. What is your opinion on that, and where do you think we are right now with the Indian Child Welfare Act as it applies to these situations and the constitutionality of it all?
Yeah, the Brackeen case is really, it's a really interesting case. A friend of mine from Navajo Nation, a person that I know, Paul Spruhan, was talking about Brackeen last week, and he called Brackeen a case, a legal case built in a lab, which is essentially what it is. There are people who have for some time, there are a lot of people that look at Indian country and they don't like the fact that tribes are able to operate as sovereigns. They want to say that Indians are a racial classification, not that Indians are a political classification. And that's a very important issue in federal Indian law. That has always been the law, that the tribes they're not racial entities, they're political entities. I mean, there are a lot of folks that would like to find a way to tear that down. And one of the ways that they want to do that is through this Brackeen case. This case, it's interesting in the sense that, in most cases, if you think about most cases involving the Indian Child Welfare Act, there are a lot of individuals' lives at stake. So you have cases, if the case is decided one way, the child will end up adopted by one family. If it's decided another way, it'll be adopted by another family. That's not the case here. All of these adoptions are finalized. No child's case is going to be upset however this case is decided. It really is just about the constitutionality of it. The decision that was made in this case, when it went up to they picked a very specific judge in Texas who had a reputation for making decisions on constitutional issues like this. So they picked the right judge. They framed the issue the way they wanted it, and were able to get it in front of the Fifth Circuit. The Fifth Circuit basically determined that there are violations. There is a violation of the law, that not that ICWA was unconstitutional. They didn't find that, but they did find that it violated what they call anti-commandeering laws. Basically, the United States was improperly telling a state what they had to do with things like active efforts and qualified expert witnesses and record keeping. These are requirements that for all of, since 1976 are requirements that states have had. And those are really important requirements, because if you don't have notice to a tribe, if you don't have to provide active efforts to reunify an Indian family, then a lot of the reasons that people have ICWA, a lot of the reasons that there are, public places like the Casey Foundation, CASA, they love ICWA. They hold it up as the gold standard. They say not only should Indian children, have to have active efforts to reunify them with their families, all children should have that right. But now these are provisions that have been, sort of pushed aside because of the decision in the Fifth Circuit. And I have to say that the Fifth Circuit's decision was kind of a mess. It was hundreds of pages long. It was a plurality decision, which means that they couldn't even get a majority of justices to agree on any particular thing. And so it was interesting that the Supreme Court would then go in and pick up, and they granted cert on every question on the constitutionality issue, on the commandeering issue. We also requested that they find cert because there were parts of ICWA that were struck down in the Fifth Circuit, and we want those provisions restored. So all parties involved have now ended up in the U.S. Supreme Court. This case has a much longer fuse than Castro Huerta. Castro Huerta was granted and then it was heard pretty much in the next few weeks. The briefing isn't even scheduled to be complete until I think August or September of next year. So there's some time on this. I believe that the court will uphold ICWA. I mean, courts have repeatedly, this is not the first time ICWA's been challenged constitutionally. And for the past 40 years, the courts have said the same thing. It is constitutional. Its goals are appropriate. It would be so incredibly harmful to Indian country if ICWA was struck down on constitutionality issues. For one thing, Indian children are still, 4 times as likely to be placed in foster care than non-Indian children. It is just really, there's still a lot of problems throughout the United States, and we really need these provisions. So, the court would have to overturn decades of precedent, and would really politicize something. Like even in this case, on the amicus side, half of the states, Democrat and Republican, supported the Indian Child Welfare Act. It has bipartisan support throughout the country. And I really hate to see something that is so good for children, something that is so necessary in Indian country, be turned into a political football because people don't like the idea that Indian tribes are political entities and are treated as governments and sovereigns in their own right. And like I said, there are just a small group of extremely, anti-Indian forces that have really set their sights on this and decided to make, our children, their political football. And I find that really difficult to accept.
Okay, yeah, I appreciate your input on that. That is a big topic as we were prepared for this, and I'm sure that there's going to be some more questions as we move along. But at this point, Councilwoman Coates, I will let you take over and go through any of the questions and the comments that you see fit and then want to go through. And Attorney Hill, I do appreciate you being here today. And Councilwoman Coates, I'll pass to you. Thank you.
Okay, thank you, Councilor Kidwell. AG Hill, there are some questions that have come in on the chat. There's one that I have, it's not necessarily on the chat, but about the ICWA case. And then most of the others that have come in are about McGirt. But before we go back to McGirt, I did want to ask what Indians generally in this country got a pretty interesting decision in a case called Herrera a couple of years ago, because many analysts say because of the experience of Justice Gorsuch, having some experience in Indian affairs, Indian law, et cetera, that virtually none of the other justices in the court have. Do you think that's going to have an impact, you know, when the briefs are filed and when the court begins to hear, you know, the arguments, and as they begin to consider this sometime next year?
Yeah, I absolutely think you're right. I think that it will have an impact. You know, diversity on the court is really important. You know, not just diversity and you know, gender and all those other things diversity is also important, but diversity of experience is important. Justice Gorsuch is a Western guy. He comes from the 10th Circuit. So he had a lot of experience with Indian country cases and understood, you know, the deep issues that are involved in Indian country. There are a lot of really bright lawyers who come from the East Coast who just never had any reason to run into an Indian law case. And it doesn't, you know, mean that they're not perfectly bright, great justices, but they just don't understand these issues very well. They've never had to wrestle with them on the fundamental levels in the ways that Justice Gorsuch has. And that showed through in Herrera, that showed through in McGirt, that he understood and had thought deeply about what does a treaty mean? What are the obligations that the United States has when it signs a treaty? Where do treaties live in our federal system? And then where do tribes live within our federal system as part of the United States? What is their sovereign authority? What would limit it? What would increase it? All of those issues are things that only Indian lawyers and people interested in Indian country issues probably put a lot of thought into. And we're lucky that Justice Gorsuch is one of those people. I think that he will continue to be a linchpin person. I would also think that he would tend to be a voice that the other justices would listen to carefully, whether they agree with him or not. They understand he has superior experience with these cases. And I like to think that they would listen carefully to what he has to say about it.
And I think it would be fair to say that he has a pretty firm grasp of the difference between a racial Indian and a political citizen of a tribal government that he can perhaps articulate to the other justices pretty effectively.
Yeah, you also have to be a bit of a student of history, which I'm sure you can appreciate maybe uniquely. You know, being a student of history is really necessary if you're going to practice Indian law, because it is all of that history that informs where we're at today. It's hard to know, you know, why doesn't the state have jurisdiction over non-Indians who commit crimes against Indians? Well, to answer that question, you have to really go back to the treaties and the relationships that existed early in this country's history to follow the thread of how we got to this place. And that's just, you know, I think Justice Gorsuch does get that.
There are a couple of other questions that have come in actually about ICWA before we go back to McGirt. One, is there someone on your staff that specializes in ICWA? And to say that we do have an entire department that specializes in ICWA, but you do have someone in the AG's office as well, correct?
That is correct. So, you know, we have the massive Indian Child Welfare Department, which is, you know, social workers who do the frontline work. If children are taken into custody and we get those notices, they pick those cases up and they say, okay, you know, is this child a member of our tribe? Do they have relatives who will care for them? Are active efforts being made? Those frontline folks. In my office, the person who is I consider to be the expert on ICWA issues is Chrissy Nemo, the Deputy Attorney General. She was the nation's, you know, sort of lead counsel on the adoptive couple case. And she's, you know, devoted a lot of her professional life to these issues. And currently the AG's office has 2 cases on cert to the U.S. Supreme Court. It's unusual for a tribe to have 1 case, let alone have 2. And so I have been the frontline person on Castro Huerta, and Chrissy has been the frontline person on this case, on Brackeen. So I'm fortunate to have her experience in the office, and we've worked together for some more years so I can count now. And she's an absolute rock star on this issue.
There's another one that's come in that how does ICWA relate to at-large citizens of the nation?
That's probably the most contact I've had with at-large citizens has been in the context of ICWA. The first 5 or 10 years of my career, I did a lot of ICWA cases. First time I ever went to California, it was because there was a Cherokee child in custody in LA County. And they just, with their parents were not getting anywhere in that case. So the ICWA interplay is that if a child is taken into custody, an Indian child is taken into custody in any state, the law requires them to send notice to the tribe. It requires them to ask, is this child an Indian? And once they find out the child's an Indian, they have to notice the tribe. Your tribe will follow up on a case no matter what state it's in. If it's in Alaska and we get a notice, someone's going to respond to that notice and say, yes, that is a Cherokee child. We would like all of the documents in this case. We want to review all of it. We want to talk to the caseworkers. So we have the out-of-district unit of ICW who does nothing but work these out-of-district cases. It certainly is more complicated to work a case when you are hundreds of thousands of miles away from the case, but we have been known to pick up and intervene and personally go into those cases. I have done that myself a time or two in my career when it was called for, when we felt like by appearing we could make a real difference in that kid's life. We're prepared to do it.
Thank you. I'll switch over to McGirt now. We have a number of questions that have come in while you were speaking and giving your presentation. This is one that comes from Phil Constantine in San Diego, and he sent emails to me, and I have not been prompt in responding, but I'll throw this to you, but with my understanding first, and how wrong am I about this? What I had always understood, and it was one of our former principal chiefs who initiated the history course, right, who used to teach it this way himself. And this is Chief Smith, of course, as most people know. It was always my understanding as a result of that the Cherokee Nation in Indian Territory was never sort of characterized legally as a reservation because we owned that land in fee simple. So it was basically private property, and in a strictly legal sense, reservation means land that is legally held in trust by the United States on behalf of that reservation. But now we are seeing quite a lot of reference to the Cherokee Reservation. So am I wrong in my interpretation of it, or are we sort of framing it from a different perspective?
I think it's in the framing. I mean, certainly it's correct. You know, the 5 tribes were removed early in the United States history, and it was unique the way that the tribes insisted upon, fee simple ownership of their land. And, you see that wrestled with a little bit in the McGirt decision. Gorsuch addresses that issue and says, there are people who argue in this case that because this land was held in fee simple, that is not a reservation. And he approaches it from a more functional viewpoint, looking at what was the function of this. The land status itself, whether it was held in trust or whether it was owned in fee for the tribes, the question that he thinks was, in the treaty, was it clear that this land was set aside as a permanent homeland for these people? And if it was, that's a reservation. That land belonged to them, and it was specifically set aside for the purpose of serving as a homeland for these people. And by his definition, the issues, the technical legal issues about whether it was fee simple or whether it was in some other legal status is irrelevant. To him, that is a reservation because it was set aside. And in our case, it was, from the Louisiana Purchase straight into fee simple ownership by the tribes. And that was sufficient for him to consider it a reservation under the law.
That's kind of what I had thought, that we're using this, and also it just really begins to emphasize in a way that, just saying reservation boundary or just saying jurisdictional boundaries or something like that doesn't quite punch in the same way that to call this a reservation now, I think, does.
Yeah, I think, I think reservation and treaty territory, I mean, there are lots of different ways to say the same thing, that this was a land set aside for and meant to be governed under exclusively the nation itself. Like those are all words that kind of mean the same thing.
Okay. We've got, there was a comment that treaties are the supreme law of the land. So how does this factor into the McGirt case and I forget what the terminology, it's really been state overreach in historically in this case rather than federal so
Right.
much, but I think it was something along those lines, right? In the federal overreach here, the overstepping of the boundaries.
Yeah, I think, there's, and one of the things I did learn in both my history course and from talking to Chief Smith, Chief Smith had been known to talk about cycles of Indian policy, the swinging. I think he described it as a swing. It would swing back and forth between, termination and self-governance. And, when the United States is caught in that termination era swing, they find lots of ways to ignore all of the promises that they made before. And that's what happened in Oklahoma. I think after statehood, the federal government should have been stepping in to ensure that the rights of tribal people and tribal governments were being respected by the state. It was bad enough that the tribes had become part of a state without ever wanting to be, despite the explicit promises of Congress in those treaties that the tribes would never be in a state. They would never be part of any state. Congress decided to break that promise, and then they sort of abandoned, after breaking that promise, abandoned the tribes and tribal people altogether. And that's just, it doesn't make sense under the law. I can't use the law to make sense of those decisions because they weren't consistent with what the law required.
Does Public Law 280 have any bearing in relation to McGirt? Oklahoma is not a PL 280 state, but is there anything at all about McGirt that would relate to that law?
Yeah,
or vice versa?
I don't think so. Public Law 280 is sort of set in stone because of some provisions. There were multiple what they call the mandatory Public Law 280 states in the United States, and there was also a provision where states could jump in and say, well, now we want to be optional Public Law 280 states, and there were other states that opted in under that. But then eventually, thanks to advocacy on behalf of tribal people, there was a provision that was put into Public Law 280, which said now, even if the state would like to take jurisdiction over Indian country under Public Law 280, they cannot do that unless there is a vote of the tribal people themselves. Like even the governments of the tribes cannot consent to it. It has to be by popular vote of the people. So there's never been a single state that has become a Public Law 280 state since that time. What we have seen instead is what we call retrocession, where states have said, we are willing to give up our exclusive jurisdiction and allow the United States to come back in and play a role in law enforcement in Indian country. So there are now provisions that allow for retrocession of that jurisdiction. So it started to actually unwind the other way. But it doesn't have any impact on the Cherokee Nation Reservation or anywhere in Oklahoma.
I think many states found the Public Law 280 to be burdensome to them anyway, didn't they? So
they did. Well, for lots of different reasons. Sometimes it was better for them to just to give up that exclusive authority that they had before.
Here's one that I'm going to read. I think pretty much verbatim from as it was posted in the chat. Something like this: does the Cherokee Nation have therapeutic jurisprudence over its juvenile and adult citizens?
We certainly do have jurisdiction over Indians who commit offenses in the reservation, whether they're juveniles or whether they're adults. Certainly we do. I assume by therapeutic jurisdiction, they're talking about to work with them in some way to rehabilitate them. Other than that, I'm not exactly sure what that would mean. Certainly for anybody who's in our criminal justice system, and there are every day, into the different cases, if there's a case that comes up and you've got someone who's committed a drug offense, our first line is not to toss them into jail, but to get them into a treatment system, to have them do a drug and alcohol assessment, follow the recommendations. There are lots of different ways where we try to provide therapeutic opportunities. I don't know if I'm exactly answering the question that was asked, but if that's my understanding of that question, that's the best answer I think I can give.
I think, as I understood it from another comment that was made later by the same person who has offered, to help to set up some things. I'm thinking it's maybe more along the lines of tribal restorative justice and some of these kinds of movements that are going on in Indian country right now. So, and the person has just said exactly. So,
Okay. Well, we
yeah.
certainly do have jurisdiction to implement restorative justice programs. Certainly we do have that. You know, and that's something that we have talked about, you know, at different times off and on throughout my, you know, I guess 19 years at the Cherokee Nation. We have at different times talked about restorative justice principles. I think, especially as we hopefully continue to see the issues in the state government begin to subside and our sense of our own workload begins to level off, we will have more resources to devote to some of those things than maybe what we do today.
I remember me asking you about this in a committee meeting, probably close to 2 years ago, at which point you virtually tore your hair out in front of us and said, maybe when we get done getting everything aligned with the state here, because we're going crazy with that right now, then we can turn to this, you know.
Yeah, and I think we are much closer today at having, and I also see that there are, you know, in order for restorative justice to have a lot of, to be particularly useful, you've got to develop some community consensus about what that means, because justice is all about the community's understanding of what justice is. And that takes time and communication efforts. Like you have to have outreach, you have to have education, you have to explain to people what restorative justice might mean and how it might affect them, and get them to buy into that. And not every community is going to view restorative justice in the same way. So it's a big thing to do. I think it's very worthwhile.
Okay, thank you. We've got some, these are getting kind of specific here. Does the Cherokee Nation now have jurisdiction over non-Cherokees on the reservation? I'm understanding this when they say non-Cherokees to mean Indians of other tribes rather than non-Indians.
Yes.
And Liza, you can correct me if I am wrong in interpreting that way.
That is
But
correct.
anyway.
The Cherokee Nation has jurisdiction over all Indians who commit offenses in our reservation on our Indian country.
So there is a case, and I'm not familiar, that in this context was being asked about Aubrey Dameron. Are you familiar?
I am.
Okay. We do not have jurisdiction over non-Indians, though, correct?
Only in limited circumstances. So we don't have jurisdiction over non-Indians if it's consistent with the special domestic violence jurisdiction of VAWA, which has recently been expanded to include not only domestic violence crimes, but I think it's in October, we will also be able to prosecute non-Indians who commit child abuse, assault on a police officer, and there's some other crimes that have been added to that. So the scope of our authority over non-Indians has been increased even fairly recently.
Mm-hmm. Okay. Then there was another one that is McGirt going to have any impacts on at-large victims? Cherokee Nation citizens.
I mean,
if they're within Cherokee Nation boundaries at the time, I presume, huh? Right. Even though they may live somewhere else.
Right. That would be the only circumstance. I mean, McGirt might, the biggest, you know, not if you were not a Cherokee in the Cherokee Reservation, but if you were a Cherokee in the Muskogee Reservation, you're under the jurisdiction of the Muskogee Nation. So you would go to their courts or the Chickasaw or any of the 5 tribes. So I suspect that even in some other tribes' jurisdictions, there might be more Cherokees than there are members of that tribe because there are just so many Cherokees. So if you go to the Quapaw Reservation and commit a crime, or you live in the Quapaw Reservation, you would find yourself in Quapaw Tribal Court. So that would probably be the biggest. If you're at large, you might still be subject to jurisdiction of another tribe because you live in their reservation boundaries.
And this is, I think there's some others about McGirt that have come in, but this is the last one of the first round. Have we been coordinating with the United Kidwell Band at all in relation to McGirt?
You know, I don't think that coordinating is probably the right word. They filed some legal briefs in some various cases asserting that they have jurisdiction, co-equal jurisdiction with the Cherokee Nation on the reservation. I do not believe that to be the case. So we are we have differing views of the law on those topics.
Yeah, if this is based in treaty provisions ultimately, and those are treaties that were made with the government called the Cherokee Nation, which is us.
That's correct.
Okay, I think we've got a couple more. Are you aware of another case in the past 100 years that has had a more pervasive impact on the Cherokee Nation than McGirt?
Wow, that's a good question. I don't think so. And maybe I'm willing to admit that perhaps that's because of the particular seat that I sit in, that it feels much more impactful to me maybe than it does to other people. But it is 100 years ago, the world that we lived in, the tribal government, even our own tribal government was just on life support. And I don't know that if we had a Cherokee who could, who we could talk to from 100 years ago, that they would be able to make sense of how much change there has been. I think this has got to be the biggest case in 100 years for sure.
Okay, and we've got one which I think is going back to, do we have any jurisdiction over non-Indians who have committed? And you were talking about VAWA, and there's some limited there, but on the major crimes, it would be the feds that have jurisdiction rather than the state, correct?
That's right. And I didn't get into all of that because it gets a little tedious for non-lawyers, I think. But for the major crimes, the United States has concurrent jurisdiction, and they typically will take jurisdiction over major crimes. So if there's a murder case, it's not unusual for the United States to ask us to go ahead and pick them up because we can just move much more quickly than they can. So we'll sometimes take them into tribal custody. And I do have a murder case pending in the tribal court now. So we have some serious cases, and we can and we do file them. But of course, the preference even from our point of view typically is that the United States will take those cases because their sentencing authority is so much greater.
Okay. I'm not sure, you may have answered this, but what exactly is the United Kituwa Band's stance as far as the McGirt case?
I would certainly not want to be accused of misrepresenting their position, something I would never do. I can only tell you my sense of it is that it is their argument that they have, whatever jurisdiction the Cherokee Nation has, that the United Kituwa Band has exactly the same jurisdiction. I understand that to be their position.
That is not what the Supreme Court decision says. However, that's not the way it's been interpreted.
Well, no, that's it is, I believe, and this is me speaking for myself now, that it is extremely clear that the Cherokee Nation is the treaty tribe, and there have been multiple decisions about that, the Cherokee Nation being the treaty tribe, and we exercise jurisdiction all within our reservation boundaries as I think the law requires us to do. So.
Here's an interesting one. Can an Indian opt out of McGirt if they are in another tribe's jurisdiction? For instance, well, a Cherokee is arrested in the Navajo reservation but does not want to be tried in Navajo courts. McGirt does not apply to any except the 5 tribes. Is that correct? So,
well,
is there a larger principle?
There is a larger principle. So, even on the Navajo, on any reservation, McGirt really spoke to what makes the reservation? How do you know if there's a reservation? But the laws of who has jurisdiction on a reservation are the same everywhere. So whether you're in the Navajo reservation or the Creek Nation reservation, it's all the same rules of criminal jurisdiction. And no, you can't opt out if they have jurisdiction over you because you are an Indian. And that's just what the rule is.
I will just share, I was giving a speeding ticket on the Navajo reservation some 20 years ago, and they automatically sent me to Gallup, New Mexico, to the state and I presume on my appearance, they didn't even think to ask if I was a tribal citizen.
Either your appearance or your tag usually is a pretty
something. Yep. Okay. What about other Oklahoma tribal nations? Ponca, Kiowa, Ota, So anyway, what is their platform regarding McGirt?
You know, as I said in my presentation, every tribe's treaties have to be viewed on their own terms. So like in the Quapaw Reservation case, they were able to put forward the argument that they've never been disestablished, and they were successful in that. Other tribes can do the same thing. They can bring the same types of cases, but they may not have the same result because it depends on, there are some tribes in Oklahoma that were the language of disestablishment was used in their treaties or in subsequent legislation, after the treaties were entered into. So I can't say without going into that tribe's very specific legal history and pulling all of the federal legislation that affects their reservation, you would have to do an independent legal analysis of every tribe's case in order to be able to answer the question of like who might be able to take advantage of this.
Wow.
A lot of good work for Indian lawyers. If anybody on here is an Indian lawyer, there's lots of work in Oklahoma. Lots of tribes probably need some assistance on these issues.
And I'm thinking maybe this is the last one. Just I'm looking at the time and everything here. So does McGirt not apply to the Plains tribes in the western half of the state on their reservations? So.
Yeah, that's sort of the same answer as the previous one. It might apply to some of them, but the only way to know that would be to do a really deep dive into that tribe's treaty histories and subsequent federal legislation.
Okay. This session is being recorded. Where and when will it be available for people to watch? It will appear on the website of the Cherokee Pins Project. And we also make them available to the communications department at the Cherokee Nation as well. So I think those will be the two places. And I want to, Councillor Kidwell, I'm going to turn it back over to you in just a moment to close it up. But I want to offer my deep, deep thanks to Attorney General Hill for giving her presentation and taking these questions this evening. I would also like to recognize some of the people who are here tonight. Ms. Hill, you may have recognized some of these names as well. Our former councilman, Jack Baker, is on this, as well as former councilwoman and speaker of the Tribal Council, Meredith Fraley, have both joined us this evening. Our former principal chief, Ross Swimmer, has been on this session tonight as well. And I see someone named Melanie, Miss Fourkiller, by any chance? Is that you? Who would be?
Yes, Julia, it's me. I could not change my name. I'm here.
I busted you here. You were trying to slide in incognito. Melanie Fourkiller, who is our former Secretary of State of the Cherokee Nation as well. We've got a couple of people who serve on our boards here. Marilyn Vann, who is on our Environmental Protection Board. And we have Patsy Edgar, who is on several boards of the Cherokee Nation. I'm not even remembering because there have been quite a few, but I know on our CCO, one of our CCO liaisons, as is Cynthia Ruiz, who is here. And then we also have Phil Powers, who worked, I know he's been very interested in the ICWA discussion because he's out of San Diego and worked as a, and continues to work as a court-appointed expert witness with ICWA for decades, made a career here in Southern California. And so many folks know Phil in that capacity as well. And then lots and lots of people from the at-large organization. So thank you to everyone who has participated tonight. And Councillor Kidwell, I will turn it back to you for some last questions and remarks. Thank you.
I appreciate you. I think you've signed us off very well there, Councilwoman Coates, and I do appreciate it. And one last thank you to Attorney General Sara Hill there for being on this and providing us with such great information. I know this is going to get recorded and watched several times. And one last plug for those of you who are out in California, Bakersfield, Fresno, Sacramento, Napa area. Hey, we're going to be seeing you this weekend. So I'm looking forward to that. And as we start off the the at-large visits again here, and we've got them scheduled out to the end of the year. And Attorney General Hill, maybe you'll be able to come out there with us one of these days and answer some of these questions face to face. I know that the at-large citizens would sure appreciate it.
I'm a sucker for Southern California, so I bet I could be talked into it pretty easy.
Yeah, I think we're all looking forward to that trip. So, hey, on that note, I'll tell everybody thank you, a huge wado for dialing in here and watching, and we'll look forward to the next one. Please, hey, send your topics for discussion that you would like to see, and so that we can get to those and schedule good presenters. And I don't know anybody's going to want to follow Attorney General Hill here. I mean, she kind of knocked it out of the ballpark, and we truly appreciate that. And on that note, we will stop recording and let everybody go on about their excellent days. Thank you.